performance management and the court's perspective. As mentioned, my name is Eddie Thiung. I practice as a tax and HR. I can request mic. Thank you. So where I practice as a tax and HR law expert, I'm also the current managing partner of Koki & Associates. It has rebranded to K&A Consulting LLP. And we are happy to be continuing the good work to offer support for HR practitioners, mostly in the space of legal.
You said what? And then you said you think about
Eddie, let me tell you a little bit. Could everybody kindly mute your? Could everybody please mute? Eddie, you can continue.
Please unmute, Eddie. Can't hear you.
Eddie, please unmute yourself. We can't hear you.
All right, sorry.
Yes.
You can hear me now?
Yes, I can.
Yes, so I think we still continue supporting HR practitioners as they try and navigate the ever-changing landscape of employment law, and also noting that the courts have become very instrumental in terms of shaping how we practice HR management. And if you've noted from the trends that continuously the questions surrounding people management are becoming complex by the day. In fact, in most of the trainings we've done, we have come to the realization that the Employment Act is one of the least amended statutes, yet it has one of the fastest growing principles of application, meaning that we have a lot of court decisions that are dictating how we do things right now that have not yet been amended to the Employment Act. And this complicates the space for managing people and also for companies and HRs who are trying to comply with the law. So the topic that I was invited to speak of today is one of such topics that has had significant contemporary growth. And why I say contemporary growth is it has remained for a long time as a very dormant space for discussion in terms of the law. And primarily, this is a space where employers were left to determine the processes and procedures of evaluating performance. But by and large, we've seen that the court's intervention has brought a lot of scrutiny as to how we apply these principles. So I'm going to be very brief, and I actually have very, very few slides. I am not a believer of PowerPoint slides. I only use them for demonstrative purposes. And my view is that by the end of it all, if there are any questions, we should spend more time engaging in a discussion, because I think this is a topic that perhaps in one way or another, you might have experienced your own fair challenges trying to apply some of the principles we will be discussing here. So I hope everyone can see my screen.
Yes, we can.
Yes, we can.
All right. So I want to start first by at least getting consensus that our understanding of performance management process is the same across, because this is a genesis of everything else I'm going to say today. And it's more or less going to guide our understanding of how the court sees it and what the law expects of us in terms of managing performance of our employees. So as usual, the performance management cycle has a couple of steps, and these steps are both legal and sometimes are administrative in nature. What you'll find is that the law does not set a standard for how to do it, but the law sets expectations of what is acceptable, and therefore employers can go up and above what I'm presenting here to just ensure that their performance management cycles are more efficient and meet the objectives of the organization. So like any other process, all performance management processes should begin with planning. And planning is indeed a multi-level approach for businesses, which starts from the corporate level of the business, and that is cascaded down into individual goals, and those goals are then cascaded down into functional items that then we assess people based on. And the human resource department, in my view, has a more significant role to play in the planning of these goals. But unfortunately, going by the organization structure we have, most of it, the corporate structures that most companies have adopted, we have more or less adopted what I call the military-based structure of organizing corporate affairs, whereby hierarchy takes precedence. And that explains why in most Kenyan companies, having taken after the British system, legal system, we will prefer calling our heads of organizations chief executive, chief operations officer. And all these are military titles because, for instance, the chief executive in military terms would essentially be the person who heads, for example, submarine. And because of that selection, we have a tendency of leaving the more weighted decisions to those who are heading the organization, as opposed to having an organization that across the board is consultative and considers work to be distributed based on expertise. And the human resource department is one of those that have been pushed down the decision hierarchy, such that delegating them to implement what comes from boards. And as such, our involvement in board decisions for HR, essentially we interact mostly through board committees or subcommittees, and therefore planning for HR and for purposes of goal setting begins after the organization has set goals. I'm a big proponent for empowering human resource practitioners to sit in boards because most of the decisions made by companies are only as good as the people who work for those companies. And when it sit and train in boards, I always say that if you don't listen to those who manage your talent, then the goals you set and the bottom line you set for your company is only a number if there is no one to implement it. And therefore it is capacity first that should measure planning as opposed to the goal determining what your workforce will do. But unfortunately, we seem to be doing things the other way around. So anyway, back to the point that planning for HR begins with a goal setting, which is an elaborate process, which is done by the board, and we interpret that into objectives, and then the line managers are able to apply those objectives and sit with their direct reportees and agree on broken down objectives for performance. Of course, we all know that these objectives should be SMART in the sense that they should be specific, measurable, attainable, realistic, and time-bound, and that's a standard that the court has adopted over time. Though you'll not find this within any statute, it's an unsaid rule of measuring objectives and clarity of objectives. So of course, once these goals have been set, there is an expectation that there should be continuous evaluation. And this continuous evaluation is what a management process is about. So there has been a significant shift from companies focusing on reviews, focusing on appraisal, as opposed to reviews. And reviews become a continuous process whereby the organization is concerned on a continuous basis to offer support for the employees, to ensure that the employees understand their goals, and where the goals have changed, it offers a chance for the line managers to pivot some of the expectations. And we saw this happening a lot in 2019 and 2020 when there was a lot of disruption due to COVID-19, and a lot of goals could not be attained, and therefore there was a lot of pivoting. And therefore, an ideal performance management system involves continuous feedback and review. And we'll see just how that comes into play when it comes to discussing questions around what is the ideal method of performance management and separation and what the court thinks about it. And you'll find that one of the greatest pillars is the performance reviews. Of course, performance reviews will take two parts, which is a continuous process of sitting down with the direct reportees and evaluating their goals. But yet the last part, which is also significant, that leads to the next slide that I'm going to discuss, is a question around appraisals. So appraisals are supposed to be systematic functions conducted by the Human Resource Department together with the line managers, and it marks the end of this cycle. And the appraisal essentially is conducted by most organizations towards the end of the financial year. If the financial year is, in most cases, the financial year will tie to the performance cycle, so that as the organization sets up new goals, it's able to issue new objectives to its people. So when we discuss sometimes performance management, there's a lot of emphasis in companies on the appraisal process, and there's sometimes no emphasis or little emphasis on questions around the review process, which we'll see for good reason in Mesha, is a reason why this space is becoming more murky and complicated for many HRs to navigate. So of course, after the appraisal, we expect that there will be an indication. There will be an indication of whether a person has passed or failed the appraisal. And that brings into perspective the question of poor performance. Now, it's still someone's mic which is on. Perhaps Judith, you can mute your mic, please. Thank you. Now Kennedy's mic is on. All right, thank you. So poor performance arises out of that evaluation process. And at the end of the cycle, you must make a decision as to whether there has been performance that meets the standard or performance that is low. So you'll find that poor performance can be as a result of two main issues. And the first issue that leads to poor performance is incapacity. And incapacity is a special element of poor performance. And this occurs whereby an employee, despite intention and ability to perform, they are not able to perform because of something that is outside their control. And in some cases, most of these issues are physical illness, mental health problems, physical disability, and so on and so forth. And therefore, what the law provides when it comes to dealing with questions of physical inability is that the employer should commence the process to separate with his employee on grounds of physical or mental or any other incapacity. And what the courts have said, again, because you'll not find this standard in any law, in the Employment Act, is that the Employment Act will say that you can actually separate on these grounds. But the courts have gone further and expanded and said, for you to separate on grounds of medical or incapacity, then the employer must commence a process to declare the employee unfit for service. And that process is a rigorous process because the courts over time have passed and said that using medical treatment notes does not fulfill the condition for the employer doing all they can to ensure that the grounds for incapacity have been proven. So instead, the standard set by the court is that the employer should at all times appoint a specialist in the area of incapacity, and the specialist should conduct an evaluation. And it is on the basis of that report that the employer can begin separation proceedings with his employee. Most cases, many employers fall back to DOSH doctors, of course, with the expectation that DOSH certified doctors are able to do a good and proper assessment. But in some cases where the incapacity is specialized, you might want to get a specialist to do this report. Otherwise, termination on the basis of incapacity without going through this process can and will be contested. And in the past, the court has awarded damages to employees who raise these issues if the process is not well done. Where we're going to dwell most today is the question around non-physical issues leading to poor performance. But before I deal with that, I'd like us to dispense off with the issue of misconduct, because if we look at the Employment Act, one of the grounds for summary dismissal is negligence in performance of duties, and that is an element of poor performance that is related to misconduct. Again, how to deal with that? You deal with it as though it were a case for disciplinary hearing where you follow the processes laid down in the Employment Act. I don't need to go through that because that's a whole new topic. But there can be incapacity that is caused by non-physical elements. And non-physical elements here are incompetence and incompatibility. And these two are the areas that the performance appraisal system tries, the performance management system tries to address and creates opportunities for improvement, because some of these items can be rectified with proper support, but yet others, such as incompatibility, cannot be rectified. So of course, I know there might be a lot of material available around poor performance and how to manage performance and the systems we are using and the pros and cons of those systems. But today I want to focus more on a case of poor performance that went to court, and we try evaluate what the court is saying about this question of poor performance and when to apply standards of the Employment Act to separate, especially on grounds of incompatibility, and how to deal with questions of incompetence. So I'll also allow, in case there's any question as I move on, you can interrupt me and ask it, or even better, if you can wait, you can actually post in the chat so that I'm not, I ensure that I'm going forward with everyone who's listening to me today. So I know we have come across this case, but this case has been the subject of a lot of analysis and discussions, and has created more or less the standard at which we apply performance management standards in the law. And it has become one of the most cited cases in cases of performance management. And in this case, in a nutshell, the facts are that the claimant was working as a restaurant manager. Then the employer established that there was fraud going on in the restaurant and commenced an audit to check whether there was any fraud. So upon completion of the audit, the employer found that there were elements of audit that touched on the roles and duties of the the claimant, and therefore the employer issued a show cause letter to the claimant on grounds of poor performance and on the grounds of fraud. So of course the claimant responded to show cause disputing the poor performance and fraud, and cited that there was not enough grounds for fair hearing that had been advanced, or rather they were not given a chance to be heard. And secondly, that there were no substantive grounds to find that the claimant had been guilty of poor performance or fraud. So remember that in all unfair termination cases, the standard for measuring fairness is twofold. One, procedural fairness and substantive fairness. So the court will evaluate those two to determine whether there is a decision to pass for unfair termination. So of course, having raised grounds of procedure and grounds of substantive soundness of the decision, the employer nonetheless went ahead and said, as far as it was concerned, it had established a case against the claimant and therefore terminated the employment contract of the claimant. And that is why the court ended up making this landmark ruling that we'll discuss. Now, in this ruling, the court went at length, and I think if you have a chance, you can look at this case. It's a very elaborate case on performance. The court went ahead and expounded at length at what is the understanding of the court's position on performance management and what is the expected standard. So first, the court observed that in the process of arriving at the decision that there was fraud, first, the employer had failed to clearly establish what was the job description of the employee, and more so pointing out that some of the allegations in the audit report touched on roles that were not clearly to be done by the employee. But secondly, the court also observed that when the finding for poor performance and fraud were being made, the employer had not complied with the requirements of the law in terms of how to deal with issues of poor performance, in terms of how to communicate the same to the employee, and at the same time, it had failed to provide the requirements for fair hearing. And in essence, what this led to the court to do is to restate what is the expectation when it comes to poor performance. And out of this ruling, the court ended up agreeing with the claimant and awarded the claimant damages for unfair termination. And in this case, the court also introduced something new, and say that in such a case, the court will consider whether the employee has been able to secure employment elsewhere out of this termination. And because of that, the court ended up awarding the maximum allowable damages for unfair termination, granting the employees 12 months of her salary as damages. So this case introduces a concept which is called the anti-abuse ring fence by the employment court. And why I call it the anti-abuse is because performance management altogether has become or can easily become an easily abused tool for employee-employer separation. So the anti-abuse ring fence is tied around a number of sections. And these sections are important because the court reads them together and they set the standard by which all performance management, terminations, and review processes should be based on. So first, Section 74 is the first section that enabled the court to make this decision. And Section 74 primarily provides that it is the responsibility of any employer to maintain records of employment and ensure that the same are availed if required. And essentially what this section says is that it places squarely the responsibility to own, record, and store data on performance management with the employer. So in the case of Jane Samba, there had been an allegation that the standard for performance had been communicated to the employee and that the employee was well aware. But in the absence of tangible evidence to demonstrate that there had been that communication, the court cited this section and said, whereas the employer could have communicated, it was not enough to just state it. It was necessary for the employer to provide material in support of that allegation, and therefore Section 74 required them that the duty of proof fell on the employer and the employer did not meet this duty. The second and very important section is Section 41, subsection 1 of the Employment Act. And this section, it carries the procedural standard for any termination proceedings. And in fact, it says that this standard must be met in almost all termination proceedings. I say almost because previously the way this section had been worded was to exclude probationary contracts because it begins by saying subject to Section 42, which deals with this process when it comes to probationary contracts. But of course, as we are aware that this position has changed, the court has since declared that section as unconstitutional on grounds that it discriminates against holders of probationary contracts because they too have a constitutional right to fair process and of course reasons for termination of their contracts. So this section goes ahead and says that where you want to terminate any employment contract, including one on the basis of performance, then you have a responsibility to explain to the employee the poor performance, to secondly, give the employee a chance to be heard and contest any allegation of poor performance. And further, when you eventually make the decision to terminate, then that decision must be communicated and the employee must be allowed then a chance to rebut that and be heard, and goes on to include the provision that the employee must be given a right to have a representative of their choice, who's an employee, or a representative from the union if the employee is unionized. And therefore, that standard complicates further the questions of performance management, because you'd imagine that performance management are an open and shut issues, especially where non-performance has been proved. But the court seems to be saying, whereas your systems have already shown this person is incompatible or is incompetent, you still have to adhere to these additional principles before you order any separation on grounds of performance. Now, lastly, and also tied to an act that was enacted in 2011 called the Fair Administrative Actions Act, that section requires that you must give reasons for your decision. So you'll find that in performance management, it's not enough to simply say we are terminating you on grounds of performance. The reasons must demonstrate how you arrived at that decision And this is a question that the court is asking, that under Section 74, because you're the custodian of these records, you would be expected then as employer to indicate what was the standard for measuring performance, how did you measure that performance, how did the employee fail, and so on and so forth. And you're able then to demonstrate that you've arrived at the decision having considered the usual standards that you've set for performance. Now, there's also Section 8. Now, the Section 8 of the Employment Act says that where poor performance is alleged, it is the responsibility of the employer to prove that poor performance. So the Employment Act is the only act that seems to interchange the burden of proof, because in normal cases, the burden of proof lies with he who alleges. But for employment matters, some cases, the burden of proof lies with the employer. So once an employee complains that the performance management system was unfair, then he shifts the burden of proof to the employer. So the employer becomes responsible to demonstrate to the court that indeed there was poor performance. And that can only be done by presenting the documents required in Section 74. And if you fail to do so, then automatically the court can find that the process of termination was unfair. Now, the other thing that you might want to note is that the court has been continuously over time, because of the inadequacy of the Employment Act, the court has been heavily borrowing from judicial precedents from Commonwealth countries or best practices from other countries. And in this case, you know that the court cited a case called Avril Home for the mentally handicapped, and the citation is right there. And using this case, the court was able to come up with a standard. And the standard that the court came up with is one that requires due process and fair hearing before dismissal on grounds of poor performance. You'd expect that such a standard then should then be included in the Act, but as began by saying that the Employment Act is one of those statutes that has not seen a lot of amendment. And for those who are aware of the history of how we ended up having this Act, would know why it's very hard for you to make any amendments to this Act. And therefore the courts have been developing a lot of this, and that's why judicial precedence becomes an important ring fence provision for performance management. At the center of it all is Section 58C. And Section 58C of the Employment Act goes to great lengths to create the standard by which performance management systems should comply with. In fact, that section specifically details and says that the performance management system should first be contained in a policy that the employee is aware of. And that policy should clearly state how performance will be measured, what amounts to good performance, what amounts to bad performance, and goes on and on and on to expound what is the expectation of the employee when it comes to performance management. If you read this judgment, and you'll find what the court quotes, and perhaps maybe just for context, I can actually read verbatim what the court says with regards to Section 58. So the court goes on to great lengths to say that under Section 8 of the Employment Act, it is the employer's responsibility to show that in arriving the decision, Section 58C further outlines the policy and the guideline and the practice guidelines that include having a performance evaluation system that can be used by the employer in ensuring the employees get a fair chance when they're called. Therefore, it is imperative on the part of the employer to show that measures were in place to enable them assess the performance of each employee, and further, what measures have been taken to address poor performance once the policy or evaluation system has been applied. So you find that the standard under Section 58C not only goes to say that you need to have the system there, but then the system needs to work in a way that demonstrates fairness when you're dealing with this employee. So we have standardized performance management, and we have metric systems that are able to score goals and are able to demonstrate the goals are measurable, whether they have been passed or not. But the elements of performance review, which is what the court is addressing here, become an essential point to look at. And the court is saying, whereas you might have that system, it is not enough to have the system and produce evidence from that system. You must then demonstrate that once you apply that system, the resulting action is one that can be clothed with fairness and objectiveness. And you will find that it's very then difficult for that standard to be applied, because what might be objective or might be a fair standard in one organization might be very different in another organization. And this leaves a concern that for those who are working in spaces where they manage people, then making the decision as to what is fair becomes a very abstract thing, and many times will be decided on a case-to-case basis. But yet again, by looking at what the court has been doing, we're able to draw lessons as to what we can do as HR managers, as HR practitioners, to at least set a guideline, sort of a lighthouse that tells us when we are on course and when we are out of course. So section 586 sits there as the centerpiece that has the substantive law that deals with performance management. So in this case, interestingly, the employer did not have a clear performance management system. Secondly, the employer did not demonstrate how the decision of poor performance was arrived at. And thirdly, the court faulted the employer for lack of objectivity in performance management. In fact, to read the judgment clearly, the court seems to be saying that performance management and poor performance cannot be used as a tool to exit employees out of employment. And therefore, it is this anti-abuse ring fence that has, since 2010, created more and more problems for performance management. Whereas the effect has not been felt because over the last decade, many companies have moved towards short-term contracts, and short-term contracts then self-terminate at the end of every year. And for the performance management cycle is not as elaborate because, of course, every new year, there's issuance of a new contract. But then it is still an issue that is still bubbling under practice of HR, and it is only a matter of time that then this becomes an issue that we'll all be dealing with. It also, it's also true that of late, many employers are really shying away from performance-based terminations, of course, because of the uncertainties that come with these requirements by the court. So the anti-abuse ring is indeed one of the measures that the court is using to create importance and awareness for performance management. But it is our view, or rather my view, that when it comes to discussing questions of performance management, legal compliance is one of the smaller issues that you have to deal with. In fact, it is the ultimate use of the performance management system and what it means for the business that should concern us more. And that's why I began by saying that in places of decision-making, it makes a lot of sense to have human resource managers or HR practitioners guiding these conversations, because it is people who at the end of the day support bottom lines. And therefore, the performance management system, notwithstanding complying with these requirements of the Employment Act, needs to do much more than that. And the biggest concern then becomes a question of what is the best way to deal with poor performance if and when it arises. And on the basis of these tricky provisions of the Employment Act, how then do we continuously bring in new talent and retain that talent? And that brings me to the discussion around the performance improvement plan. So, of course, I have highlighted some of the legal risks involved in the management of performance. And of course, if the performance management system is faulty or the termination process is unfair, then you'll have cases of unwrongful termination, which I've just mentioned in the case of Jane Samba. You'll have unfair labor practice claims, you'll have constructive termination. And by the way, constructive termination is another important area of the development of employment law. First, we don't have any statute that deals with constructive termination. Again, these are creature of the courts, and the court has developed this standard to become a standard that is applicable and acceptable, so that employers are given the responsibility to regulate the workplace, and they have a duty to ensure that the workplace is safe from a hazard that can cause make it difficult for our employees to thrive. And therefore, the topic around constructive termination is also another heated topic that requires another session, perhaps, to just even break down what it means to be terminated on a constructive termination basis. Now, non-legal risks, which are some of the elements that we'll try cover in PAP, is that non-legal risks are such as absenteeism, resignations, business performance can become, can fall. Then there's overall, let me move this. So there's overall financial business loss. There's poor performance of the employees or generally the department. But most importantly, and especially in an age of information technology, is the reputation of the employer. So there is nothing that can drag an organization more through the mud than an assumption that the employer is a bad employer. Because essentially, even where the employer has made a decision that is legally sound, that connotation can lead to a lot of litigation, even where there is no need to litigate. And secondly, our courts are ran by human beings as you and I, who are also susceptible to public opinion. And sometimes if an organization is known to be an employer of bad reputation, it can easily influence how the arguments or the processes or determinations done by the organization are considered. And therefore it makes sense that as you consider performance management, these intangible elements of it are important, are an important consideration to avoid instances where you're legally compliant, but again, you miss out on the non-legal aspects of it that make you a good employer. So, sorry. So again, if you want to run up an effective performance management, the summary of what I've been saying in the summary of going through the anti-abuse ring fence of the court is to make sure that the performance management is relevant to the job. You remember in the case of Jane Samba, one of the things the court said is that whereas the expectation to book members, to book guests was a requirement within the organization, it was not in the job description of this particular employee, and it was not a method by which they were assessing her performance. And therefore, that standard, though spoken of and agreed to, was not relevant to the performance of the employee's job. Secondly, the system must be able to distinguish between effective and ineffective performance. And that is a creature of Section 5.8, which says you must demonstrate how you distinguish between good performance and bad performance. And lastly, is a standard of fairness and acceptability. And here I have put into bracket independent and unbiased. So because the court is accusing employers of using employment performance management as a tool to exit employees, then it then raises the question of whether what makes a performance management system fair and acceptable. One, compliance with the law is one of the standards. But also you remember that performance management systems mainly are faulted for lack of objectivity, in the sense that the current performance management systems are ran with the HR as the custodian of the process, but the actual performance management is done by non-human resource practitioners, and these are managers. But then it begs the question whether where a manager is not clearly aware of the processes, or where a manager clearly wants to exit an employee for other reasons apart from performance, whether that manager can still be the ideal candidate to sit with his employee on performance improvement plans. And that question there is a question that has come up severally before the courts. And it seems to be that where one person is the prosecutor, they cannot be the judge and the jury. And that is the reason why many performance-based terminations usually end up in court, because of the unfairness of how it's done and the lack of independence of how the performance improvement plan is run. So then the question that, or rather what has happened or what needs to happen is that whereas we have moved away from quantitative performance management to more qualitative performance management, having the traditional performance management systems that emphasize on the past, emphasizing on personal performance and looking over the improvement of performance over the years, and doing annual reviews, meaning that in the whole year, the managers have no responsibility over the performance of employees and they only care about the appraisals, then the cycle of performance seems to be tied only to the appraisal part, which is the last part of the cycle. Then managers take lead, meaning that the employees do not own the decisions. In fact, the employees are supposed to implement, and therefore there is no clear room to give feedback. And lastly, this traditional system seems to focus more on the weakness of the employees rather than the circumstances that lead to poor performance. And this explains why, if you put an employee in performance improvement plans where you are trying to address only the weakness of this employee, in many times that performance improvement plan will be questionable and challenged in court. Because in essence, poor performance does not happen in a vacuum. You remember we say that poor performance can be on the basis of incompetence or incompatibility. So the law requires you under the PIP program to think through whether if this poor performance has been occasioned by, for example, the person is placed in a department where their talents are not well utilized, you give them a chance to improve their performance by perhaps redeploying them or redesigning the work. And therefore, focusing on weakness is the first step towards an improper performance system. Now, instead of focusing on weaknesses, addressing the question of what went wrong cannot be done at the end of the performance cycle. It has to be a continuous discussion. So remember, for example, in a case where an employee is supposed to meet certain sales objectives, it is then essential that the employer demonstrates that throughout the year, they provided the requisite tools and support for this employee to meet those standards. It will not be enough to say, we told you to sell X volumes and you didn't sell, whereas you're not able to demonstrate that within your effort you have done all there is to do to support this employee. And therefore the question of continuous evaluation and evaluating the circumstances for performance becomes a question in the new space of practice. So we are currently, and I think there are very few companies still doing the appraisal method, but there has been a move towards a more involving and consultative performance management, where the employees are encouraged to take ownership, where the discussions on performance management are actually consultative in nature. And even the court actually, in this case, you'll see the court goes again to elaborate what it deems an ideal performance management system. And the court seems to say, one where there is discussions around performance and where the employee is given a chance to give feedback, and even where there is objectivity that the peers or other parties are allowed to also objectively review this employee, that seems to be the ideal performance management standard that the court is looking for. And lastly, the new practice is tied so much around independence and non-biased PIP systems. So non-biased PIP systems serve two roles, and I think I should go to the next slide so that I wind up. So the ideal PIP standard has two main components. One, that the success of this standard of the PIP program must be measurable. Again, is to say that once an employee has failed, then you must develop new goals. And these goals must be measurable, specifically tied to the performance of the employee. For example, if an employee does not sell the volumes you want them to sell, then an improper PIP will place this employee on PIP and require them to sell the same volumes. Essentially what you've done, they've not identified an area of improvement in performance. Instead, asking what is wrong with the performance will tell you, is this person lacking in terms of team performance? And therefore the PIP goal there should be for them to improve on their ability to work with others. And that becomes a personal improvement action point for them, as opposed to regurgitating the same goals that were set in the objectives. You want now to design goals that are clearly directed to improving performance. But then secondly, is a question of fairness. That the performance improvement process must have continuous support, and the employer must demonstrate how they've supported this employee. Unfortunately, many employers place employees on PIP with the managers who did their scoring, and sometimes these managers, by virtue of being the ones who've led the PIP, are usually the most biased and are not able to objectively evaluate improvement. And you find that PIP in many companies has become a tool by which employees are exited from the business. As HRs, our concern should then be, what is the cost of replacing these employees? What does it mean when we have employees who are living through PIP? Does it then fault our recruitment standards? Do we have clear standards for recruitment? Are we recruiting incompatible people, and what can be done? And therefore that discussion goes far beyond simply placing someone on PIP and waiting for it to expire, then you fire them. In fact, performance improvement programs should be a place of inspiration where employees feel inspired to integrate with the others and pull up their socks to work objectively. And therefore, there has been a trend, and we are currently also supporting a couple of our clients where the PIP program is becoming more of a thing that is externally outsourced, so that someone else who is able to interpret the SOPs and the objectives of the business is able to offer the required support. And in the era and age of mental health issues, PIP program actually, I was actually reading a report the other day, PIP programs have become a basis for serious mental issues. In fact, when an employee is placed on PIP, it's a place where that causes a lot of trauma. And even if someone comes out of PIP, the odds of them integrating back to their departments is usually very slim. And therefore, for us, I think it's a place that needs to be taken with a bit more care and concern, so that you do not end up become an employer who is known for pushing people to the edge, and when they leave the organization, they're incompatible to work elsewhere. And therefore, once you attain those two standards, you not only comply with the law, but you also create an environment where your employees are able to continuously grow and continuously improve their skills and support each other for the betterment of the organization. So I think that's it from me. And that's all I had for today. I know I've raised a number of issues or touched on a number of topics that might require further expanding on. I therefore allow, if there are any questions that I can take, I'm more than happy to take them, or any comments. Back to you, Beatrice. Thank you.
Thank you very much, Eddie. I've really learned a lot, and I believe my colleagues have. Now, there's a question which was raised by Linda Saida. What is the best way of handling mental health issues brought about whenever employees' performance is questioned? How do we deal with these mental issues? Excuse.
Right. So first, I like to believe that mental health should never be considered as an excuse, because mental health takes different formats and forms. But I think the best way to deal with mental health issues is first, if it's raised during PIP, then of course, then that can become a serious ground for the PIP program being contested. So during PIP, if mental health issues are raised, it is a responsibility of the organization to demonstrate support for this employee during such process. In fact, if an issue of mental health is raised, then many times the performance you're dealing with is no longer a performance of incompetence and incompatibility. It then becomes a poor performance based on incapacity. And you might want to explore this and see whether indeed you are able to separate with this employee on grounds of incapacity. Otherwise, if you insist on proceeding with PIP programs with an employee who's already demonstrated that they have incapacity problems, then of course, even in terms of you measuring that performance becomes hard, because even the level of understanding can be brought into question. And therefore, I think for me, I'd be more inclined towards first treating it as an important thing, but then again, trying to classify it as and when it arises into this clear classification of what kind of poor performance it is. Otherwise, insisting on going through the performance improvement plan where you have mental issue concerned can actually lead to constructive termination, where the employee resigns and alleges that the PIP program was too harsh for them to cope. And that becomes, of course, a case for the court to consider.
Okay. Then there's another question raised by Dr. Elijah. He says, Eddie, please comment on performance management in the public service and its attendance tools like performance contracting, staff appraisal, and appraisal system. staff performance appraisal system?
Right. So, so if you look at the Employment Act does not try to define the employer differently. In fact, it just defines an employer in general terms. And there has been previous decisions where the courts have said that public servants are also entitled to the standards set out in the Employment Act, and the government is a qualified employer, and the government also needs to comply with the requirements of the Employment Act. In fact, if anything, the standard for the government is actually much, much higher. In fact, where administrative action is to be taken by a public body such as the government, then the standard for communicating that and the standard for affecting the rights of the employee are not only protected by the Employment Act, but also protected by the Constitution. And therefore, it goes without saying that the performance appraisal systems of the government, first, I know the government has standardized them, but even with this standardization, they must meet the qualitative elements of performance management. So whereas the government would require you, and I think there's a case, I can't remember the case, but there's a case whereby a government employee was was reinstated by the court, and then went back to work, but the employer refused to allocate work to this employee. And therefore, this employee sued the employer for lack of engagement. And one of the things that came out is that whereas this person was being paid by the government and all other factors were being, all other benefits were being given to this person, that the employer had an objective to engage this employee, had an obligation to set objectives with this employee and to continuously help this employee improve in their performance. And therefore, it goes without saying that the standard when it comes to appraisals for government, it is also the same standard we're applying, that there has to be clear demonstration of compliance with the ring fence that I've mentioned, and more so with section 5.8 that demonstrates, section 41 and 5.8 that demonstrate good procedure and good policies that demonstrate how performance will be done. Otherwise, I wouldn't want to imagine that there's anyone in government who would imagine they have a special standard for how to deal with their employees.
Okay, there's another question by Nancy. She says, if an employee is on 6 months probation, a salesperson, and they haven't produced, and their probation is to end, how long is fair enough to alert the employee that we won't renew the contract? Is it a month?
All right, so if you look at section 42 that deals with the probation contracts, one of the contests that has been raised over time is that that section was designed in a way that you could terminate employees on probation contract without notice. But there has also been, I want to say, a fallacy that has been spread by either people who are trying to interpret the law, that the court has created a mandatory notice period. In fact, what the court has done, that the court has said that whereas you may terminate these contracts, you must terminate this contract using a fair labor practice. And one of the things that the court has done is to introduce the necessity for notice, or the necessity for reasons. So if you want to terminate employment on the basis of non-performance, and actually that's actually two different things, because the question by Nancy is, you want to communicate non-renewal. Now, those are two very distinct elements, because non-confirmation is a question of notice, and because it's a probation contract that is standing alone from the rest of the contract, if that's the case, then a simple notice of saying you're not going to renew the contract then can suffice. But where the contract is tied together with a long-term, with a fixed-term contract, and the probation contract is just a period of the fixed-term contract, because of questions of legitimate expectations, then of course you'll be expected to at least give reasons and demonstrate how you arrived at the decision that this person is not a good fit, and therefore for performance management purposes, the Fair Administrative Actions Act would require you to give proper reasons for why you're not going to renew. And that goes back to an important point that I want to make, that even for probationary contracts, when they commence, it's necessary for you to set clear objectives and demonstrate how performance will be measured. Otherwise, it's not enough to say you didn't meet expectations. Otherwise, then that becomes a ground for termination that is not substantive enough to hold in court. But all said and done, there is a general requirement that when any administrative action is taken, employees are entitled to reasons. The reasons might be inept or might be satisfactory, but what the law is saying that fair labor practice requires you before you take a decision, and when you take a decision, to not only communicate the decision, but also attach the reasons why you're not renewing. And I think in the case of non-renewal, of course, a simple statement that you're not going to renew because you're not able to, or for whatever reason, will be enough, because by that time there's no contract.
Okay. Okay. This presentation, if I'd like to inform everyone, will be recorded, and IHRM will forward the recording of the presentation. Now, I'd request anyone who has any more queries or questions, you can raise your hand, then I'll unmute you so that you can ask the questions to Eddie. And then I can see here there's a Carol wrote, am I the only one lost about section 5.8? Is there an amendment that I missed out on? Maybe Eddie, you can clarify on that.
So perhaps I can get more details on the question, because
Carol, maybe you can raise your hand and unmute you, then you can ask your question. Carol Mushiri, are you present?
Yes, I am.
Okay, maybe you can ask your question.
Yes, thank you. Eddie, I was just looking at my Employment Act, and actually it doesn't have a section 5.8. Section 5 primarily talks about discrimination in employment, but it doesn't have a subsection 8. So I was lost, because I'm wondering, is there an amendment I'm not aware of, or are you maybe looking at something else?
Sorry, my apologies. I actually just realized that it was a typo in the presentation. I think the proper section is section 10, that deals with the conditions of employment. Let me get the proper section. I think when I was translating the notes, I must have mistyped it. Sorry about that. Or maybe I can take another question as I get the correct section. My apologies.
Okay. I'm out. Okay, Hannah is talking about on outsourcing PIP. Can you recommend a company?
So yes, first, outsourcing of PIP is something that is a bit new. I don't think I'd recommend any other company apart from ourselves, because we're currently doing it. We've developed sound PIP programs, and we infuse in them a training calendar for managers, because we know the biggest challenge to PIP is non-HR practitioners, and therefore, as companies are developing their training calendar for the year, we sit with them and try infuse some of the trainings that will guide when it comes to doing eventual PIP. So of course, if Hannah, it's something you'd be interested in exploring further, I mean, you can reach out to me, we can have a discussion and see how to go about it.
Okay, then there is Jared, who is asking, what is considered a reasonable period for executing PIP programs before termination?
So again, thanks for that question. Again, you'll find that the PIP period many times is left on the discretion of the employer, and also depends on the type of contract an employee is on. And therefore, PIP programs can be extended. I know many organizations will do 3 months, but you can also be extended to another 3 months. But the threshold really is a question of reasonableness. What is ideally reasonable in the circumstances of the contract? For example, if someone is having 1 year's contract and you place them on PIP for 6 months, then unless there are very good reasons why the PIP is being extended, then you might have challenges. So I don't want to say that there's a specific requirement, but I'm saying general good practice requires reasonableness and the importance of the role. Then secondly, the extension of PIP can also be measured against what are the limitations of the rules. Sometimes in some professions, if you're placed on PIP, for example, in the case of law firms, if I may say, then you are restricted from handling any client work without supervision by someone who's superior, and you also have some limitation in terms of the kind of work you can do, because PIP in some instances has a way of limiting engagement. Then the principle of reasonableness needs to be applied so that you're not found to have been guilty of employing an engagement which, as I'd mentioned, has become an issue that the courts have addressed in the past.
Okay, I think that question has been answered. Then there is Nancy Rispa. Maybe you can ask your question. I don't understand what you're saying by non-confirmation. Nancy, are you still on?
My question was probably if Eddie could touch on. I had gone offline. I don't know how long you said that we should do the PIP before termination on probation. If you're terminating on probation, then how long before the probation ends should we start having the PIP? And then also the other question was, if, let's say, for example, the employee has been has not been performing but has been in the organization for long, then how long should we also have the PIP plan for them? I was offline when you are answering that.
All right, thank you. So what I mentioned is that I wouldn't say that there's a specified period when PIP should run, because the way you design PIP programs depend on the nature of contract and the nature of work being undertaken by the employee. And I said, for example, in the case of some PIPs, they have an automatic way of scaling down benefits and scaling down engagements. So the court will be evaluating whether by putting someone under PIP, you are able to balance the measure between the right to fair practice, which includes engagement and non-discrimination, and correcting poor performance. So that if you place someone on PIP for inordinately long period of time, the standard to be applied is a standard of whether it's reasonable in the circumstances. And therefore, what's reasonable for one company might be unreasonable for another company. Especially, for example, if you take the example of a surgeon, for example, and someone who's doing work that can easily be learned, then you'd find that what's reasonable for PIP in one is actually very, very unreasonable for the end. Therefore, it's a standard of making sure that the engagement on PIP has a bit of resounding reasonableness.
Okay.
Thank you.
Nancy, do you have another question? Or I can move on to somebody else.
One.
Okay, Cecilia Mudhoni is asking if you have an employee who is inconsistent in performance. Sometimes he performs well and other times below performance, despite having all the tools and clear guidelines. How can that be handled?
So what was the question?
An employee who is performing well today, then tomorrow below standard. How can that be handled?
So you know, at the end of every performance cycle, so the employer has a discretion first. Even if someone goes through PIP and they're successful, the employer has the prerogative to issue a warning letter, even if you're going to re-engage, because performance is one of the required standards for engagement on the contract. So sometimes how you deal with fluctuating performance, I think issuance of warning letters, and many policies provide that if you have more than a number of warning letters in a period of time, then it can actually lead to termination. But then the challenge with the movement up and down of performance standards is that the performance cycle is deemed to end at the end of every performance appraisal, and therefore it will be very hard for you to bring up past performance where there is good performance in this year, unless now there is a clear provision in your policy that allows you to continuously monitor performance and build on previous performance, or of course allows you to also issue warning letters. So I think it's more of a policy point of view But what the law would be concerned about is whether there was fairness in arriving at that decision. And therefore, where you have employees who are moving up and down the performance line, then the question would be to go back to your policy and see whether for poor performance, it allows you to issue warning letters or to have a policy that is clear on how many times you can be on PIP before disciplinary action is taken.
Okay. And then I'd like to inform everyone the recording has already been sent, the link for the recording. So you can get that one. And then Doreen is saying, she's saying on section 5.8, it may be a typo in the older editions of the Act. Section 5.3 was repeated twice in later editions. 5.7 is 5.8.
Yeah, that could be the confusion. That could be the confusion. In fact, I was trying to just look back, and I realized we made the provisions for ring fence using the judgment. And I was just trying to cross check whether we could have been a question of amendment. But anyway, I'll still look at it. Maybe that's an explanation, but let me still look at it. Perhaps I can share that with you, Beatrice, maybe even leave it after this and send the clarification so that you can circulate it.
Okay. I think we've handled most of the question. Is there somebody with a question?
Yes.
Okay.
Olga.
Yes, just go ahead.
My name is Olga, and I wanted to ask, first and foremost, I want to appreciate you for this session. It's really enriching. Secondly, is to ask a question. Is there the upper limit? Is there a ceiling to a PIP? Is there a ceiling? Because we know that, okay, in consideration of the law of the diminishing returns, we know that organizations can grow and then they start. Hello?
Yes, you can hear you. Olga,
hello, are you here?
Continue.
Okay. Yeah, is there a ceiling to a PIP? Because there's the law of diminishing returns where the performance of an organization may begin to stagnate. And definitely, even as you continue to push and push and push the staff, they may not be able to go beyond a certain limit. I would, maybe this question would be in reference to sales executives who may feel that they're being pushed beyond their limits, because as they continue selling, there will be the tendency of organizations to want to increase their targets, buy and put in PIP measures, and if they don't accomplish, therefore they are sacked from the companies. So that is the main question. Is there a ceiling to a PIP? And push the staff, they may not be able to go beyond a certain limit.
So first, I repeat what I've said. I haven't come across that the law has a ceiling for PIP. But you remember what we said, that when it comes to setting objectives, one of the requirements for the objectives are they must be SMART. So if, for example, your sales team did not achieve their requirements for their targets for last year, and there was good reasons why many people didn't achieve, and then subsequently you set the same goal and they still don't achieve that goal, then ideally on the third year, if you're to set the same goal and punish anyone for non-performance, then the question of that goal being SMART comes into context. One, is it realistic? And if it's realistic, then you must demonstrate what kind of support you've given from year one, different from year two, that will enable these people to perform as you would. And therefore, I'd say that as the organizations grow, and that's a factor, especially when you are in a declining industry. And I think that some, or actually most of manufacturing companies are either in sunset industries where there's very high competition. No matter how much you push, you have stiff competition from online shops and e-commerce establishments, then the sales numbers might actually start dipping. But what would be the realistic approach to it is to ask whether the goal that has been set, whether it is realistic or not. So that even if you place someone on PIP, and I said, for example, placing someone on PIP so that they can sell more is inherently for PIP a wrong goal, because it does not identify the weakness in the performance. Essentially, it only addresses the problem. But if someone is not selling well because they are not putting enough effort, then the goal then for these persons to improve on is their ability to work harder or put in more effort. If someone is not selling because, for example, they're not cooperating with other team members, then the goal for PIP becomes teamwork as an item for PIP. But then if you were to regurgitate the same goal and say you need to sell 10 million and they still don't sell 10 million, then there are very high chances that the objective set both at the beginning of the performance management cycle and at the end of PIP, both of them might appear to be very unrealistic. So I think you wouldn't find a clear ceiling for PIP, depends on the company. But again, of course, the standard is that all goals must be realistic so that in sunset years, the company has a bigger responsibility to demonstrate performance, demonstrate support for improved performance of its sales team.
Thank you. Thank you for that.
Okay, is there anybody else with a question?
Yes.
Yeah.
Okay, please go ahead.
Okay, I don't know whether I can go. My name is Purity Nderi. I have two questions. Okay, so question one is on the probationary hearing. So knowing most probations are usually limited to either 3 months or 6 months. I think the law just puts it at 6 months with an extension based on discussion. So if, or in the instance where an employee is not performing and you need to take them through a hearing, and you know, and this should be done within the probationary period, at what point should this discussion be kickstarted? Is it right, how do you say, in terms of structuring, right before the end? And then in terms of period and the notices, the show cause letters and all this, should all this be done still within that probationary period, right before that period ends? Or do you wait until the probationary period ends, say it's supposed to end today, then you kickstart the hearing process in respect to performance? Yes.
Right.
And then now the other question is, with respect to the hearing or the disciplinary process, the show cause letters, I know sufficient or reasonable period should be given when issuing the notices, but what is reasonable period? Is it 1 day, 2 days, 3, 4 days? People interpret it differently, and their policy and most policies are not very clear on the time period for the notices as they go out. Yeah.
Right. So thank you, Purity, for your 2 questions. So on the first question, all probationary related communication, whether it's a non-renewal, whether it's termination, should be done before expiry of the probationary period. If an employee outlives his probationary period without communication from an employer, then the principle of legitimate expectation would apply, and this employee would be deemed to be serving on a long-term contract with the employer and therefore becoming entitled to other benefits that come with that kind of a contract. And therefore it would be very risky for you to wait until the end of the probation period for you to begin these discussions. On the other hand, to answer the question whether the hearing should be, or the hearing for performance should be done a month to, prior to, I think it's a question of how the probationary contract is drafted. So we have probationary provisions. Let me say, there's a probationary contract and there is a probationary clause. Probationary clause would exist within a long-term contract, but a probationary contract is a standalone contract that has a term of 6 months. And therefore, if you're dealing with a probationary contract, then at the expiry of the 6th month, the employer is supposed to give notice of non-renewal with reasons for non-renewal. If the reasons touch on performance, then the employer must then communicate the reasons and clearly illustrate them as required by the interpretation of the Court of Section 42. If the contract is tied to a long-term contract, it's just a clause within a contract, then those ones are the ones that have the highest risk because the question of legitimate expectations become very, very clear. So in essence, what you need to do is that you need to commence the process of appraisal. Instead of thinking of probation as a thing you do at the end of the term, it should be approached from a reviewing point of view. In fact, the better performance, the better probationary contracts are the ones that are run on a month-to-month basis in terms of review, so that whoever is attached to these particular employee serving probation has a responsibility on a month-to-month to continuously evaluate and give score and have those meetings with the employee for them to indicate what are the areas of non-conformity and so on and so forth. So that at the end of the probationary period, it is a summary of those many sittings that you use to indicate non-conformity. Now, the challenge with doing the performance at the end is that many times the probationary contracts that are contested are usually contested on the grounds that the employer did not offer support for the person when they were on probation, and therefore it is the employer who's prevented them from performing. And a good example is where the employer, for example, fails to conduct an induction, where the employer, for example, fails to clearly appoint a direct reportee for the person serving probation, and therefore this person serves probation without guidance, then you will not be able to terminate them for them not being able to meet the requirement. So the second question you've asked has to do with, would I remember? Remember the second question?
The notices. How sufficient notice? If you're rolling out the respective show cause letter, then the responses, the notices basically sufficient time in between. As you roll out.
I now remember it. So the question of the question of notices again is the law uses the word reasonable, because the law doesn't want to dictate circumstances for each organization. For example, if we are going to discipline a teller who works for a bank or someone who does important work for an organization, then it would make sense that if the work being done is of a sensitive nature, that the notice to that person then can be as short as possible to avert any further damage. If, for example, you're dealing with a case of a surgeon, for example, who needs to be disciplined, then of course it would be unreasonable for you to give them 1 week, 2 weeks, 3 weeks, whereas we have patients' life on the line. So the question of reasonability depends on, one, the nature of contract, the type of engagement, and the circumstances prevailing. But of course, if you look at the Fair Administrative Actions Act, it will provide, you need to provide sufficient time for this person to be able to respond. So many people assume, or the standard set is that a notice period of 3 days is sufficient time. But then again, per organization, what needs to be looked at is what is the normal course of notices and how do you give your notices on normal operational duties. So you'll find that many organizations will perhaps say, our SLA requires us to respond within this period of time and so on and so forth, and therefore it's reasonable for us to say 2 or 3 days make a lot of sense. But then again, in special circumstances, you can argue why you want to issue your notices at a shorter period of time. Then secondly, and the most important thing to consider is that you remember the employee when you're giving show cause notices, for example, you must give them sufficient time. For example, show cause notices and DC notices, you must give them sufficient time to appoint someone to come with them and to represent them. So of course, you must measure whether the time you're giving is sufficient for them to be able to bring on board someone to support them and be able to defend themselves adequately. So I wouldn't say that I can prescribe what is the ideal time, but a question of reasonableness depends on the circumstances and the organization.
Thank you.
Okay, there are people who are asking for your contact. The contact has been posted. So those who want to get in touch with Eddie can get the contact there in the chats. And then, is there anyone else with a question before we've gone past our time? So
hello.
Interesting issue.
Hi, this is Dixon.
Sorry, could it be one person talk first, and then the other could hold for a little bit?
I think I'm next representing Kennedy.
Okay, you are Faith.
Hi, Beatrice. No, Kennedy Risiki.
Oh, Kennedy. Okay, fine.
Yeah, we are a group from our department. Mine is just a comment. And my comment lingers around what the pandemic that hit the hospitality industry. We are in hospitality industry, and mine is about the employer's lenience on the objectives or performance objectives that have been set to the employees. Now, you've set clear performance objectives. The pandemic is here, it has hit the industry, closure of businesses, resume the businesses. And like right now, we are recovering from the pandemic. So I think there is a call for that lenience by the employer in terms of the performance objectives. Maybe, the employees that were put on performance improvement plan. I like the point whereby the employer is supposed to support the employee who is on performance improvement plan because mentally that employee, what is going through their mind is that, you know, they are on their way of, this is a one way of exiting me from employment. So that the section is so commendable, and maybe at some point we went off, and I would like some clarification on exiting an employee whose PIP has come to an end and maybe they are unable to perform. You know, according to the review on the PIP, the employee is, it has been established that this employee has not performed as per the set points on PIP. Maybe is there a clear way or way of exiting this employee? Thank you.
So right, thank you. So on the second part, I think I had elaborated at length, and I think Beatrice has mentioned the recording will be made available, and I think you'll be able to hear the response because I went a bit at length to explain the process of exiting the employees when they fail PIP at the end. But to address the question around leniency when it comes to performance, you remember that smart goals are not static. So what is smart today will not be smart tomorrow. And I think if there's one thing we've learned as employers is that when we began the year in 2020, in 2019, the goal set for that year became unreasonable when COVID began. And therefore, if you are to insist on holding an employee accountable for the goals you set in a year where the circumstances have changed so much that they're no longer able to perform normally, then that goal stops becoming realistic. Actually, it also stops becoming attainable. So assuming the hospitality industry where the government locked up almost all hotels and required people not to have in-person engagements, then to punish a sales team for not delivering sales for such kind of a year, then of course the employer would really, really struggle to demonstrate how that goal was attainable in the circumstances leading to the year. And therefore, what the law then will ask is, one, how we measure whether a goal is smart is you need to demonstrate that you offered all the requisite support and that support was sufficient for these employees to meet these goals. And secondly, you must also demonstrate that inherently across those who are doing similar responsibilities, there was actually substantive attainment of that goal for it to be considered attainable and realistic. So I think for me, it would go back, if this was to become an issue of discussion, it would go back to whether the goal by itself fulfills the requirements of the Employment Act, whether it's measurable or attainable.
Okay, now I think we'll take two questions, one from Dixon and then Faith. Dixon, go ahead.
Yes. Thank you, Eddie. I think we've had a good session. Mine is it's a small twist to the whole concept. And this is where we are now moving away. In order to avoid termination on the basis of performance, we have moved into short-term contracts, even on areas where it is very clearly that these roles are long-term. Are we not in contravention of the ILO Convention 158? And we might suffer the same in an event that the employee demonstrate that the contract that he is having is long-term in nature, but because to avoid all this, we are giving short-term contracts. Maybe you can comment on the ILO Convention 158.
Right. So thanks, Dixon. And indeed, it's a good issue raised. First, the The ILO Convention with regards to engagement of employees and longevity of service is tied back to the question of fair labor practices. And in fact, we borrowed heavily from the ILO Convention with that regard when we were drafting our constitution in terms of fair labor practices. And you'll find that the standard is where an employer takes up a measure to disadvantage or limit the rights of an employee, then the court is easily able to interpret that to be an unfair labor practice. So there has been a lot of cases, and then you can actually also look at them, that unions have moved to court to challenge the idea of breakage of service. And breakage of service has become common in outsourcing contracts, where the court has been trying to interpret whether by outsourcing functions, is an employer disadvantaging employees in the sense that they're able to break their contracts of service, and at the end of the day, affect how you calculate service pay or severance. So I think, in my view, and I'm not saying this is what the law is, and I think, in my view, it's one of those issues that is, we're just waiting for it to happen. We're exactly where South Africa was a couple of years ahead of us, and South Africa has now fully regulated the labor market in the sense that you cannot hire short-term where the role is expected to be available. In fact, one of the biggest challenges you'll have is where the contracts are short-term, but in the subsequent year you recruit a similar person for the same role without giving this other person a chance to either apply for the job or without giving them good reasons why they're not eligible for that role. And even worse, we have seen instances where people are serving short-term contracts continuously for a period of many, many years. When it comes to eventually calculating years of service, for example, in redundancy, that has become an issue. It has been raised in abstract, but there has been no clear discussion around it. And I so agree with you, Dixon. It's just an issue that is permissible for now because no one is challenging it, but more or less it's going to become an issue in years to come, especially if we start applying best employment standards of employee engagement, and of course trying to make the employment relationship one that is free of unfair labor practice.
Okay, I think that question is answered. Faith Naika. Faith, are you present?
So Beatrice, I think if there are no more questions, I can hand it over back to you. Beatrice, if you're there. Beatrice, if you're trying to speak, I think you're on mute.
Okay, now you can hear me.
Yeah, we can hear you.
Okay, all right.
Yes, Eddie has posted his office contacts and email. So if anybody has a query, they can get in touch with him using the email. And then the recording has been posted on our chat by HRM and also our Vice Chair, Mr. Gathuka. So if there's anyone who wants to go through it later, they can maybe download it from there. And then if there are no other questions, I'd like to thank everyone for attending this session.
Hello.
Hello, Richard, you have a question? Richard, you have a question? Okay, then what I can say is thank you everyone for attending. And then we'd like to end this session at the moment. Then everybody is free to leave.
All right, thank you, Beatrice. Thank you, everyone. Hope to talk to you guys soon. Bye.
Okay, welcome.
Yeah, I have a question, Beatrice.
I'm sorry, the Richard, I called you, but I think the speaker has already left. Hello. Hello, Richard. Richard. Okay, I think the session has ended. Everybody, thank you very much and have a lovely evening.